headset?
Certainly.
Where's your headset?
Ma'am?
Could you give me a second, sir?
Excuse me.
Do not raise your voice to me, sir.
I wasn't raising my voice.
Is there a problem here, sir?
Not a problem.
Calm down.
I am calm. What is it with you people?
You people.
It's a movie.
I'm only gonna say this one more time, sir. Calm down.
I'm calm!
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And, you know, there's a lot of things about this case that can really, if you're following it and you're emotionally involved, like I try not to be emotionally involved, but, it's kind of hard not to be emotionally involved when you've spent as much time and effort on something as I have. And I know a lot of you out there following it have as well. So when certain things happen, the natural response is to get angry about it. But that's where really cooler heads prevail. So anger is never going to lead you in the right path. A cool head will. And I'm kind of telling you this as I'm telling myself this, because we got the ruling on the motion to preclude the death penalty due to disclosure violations, which I truly believed was the best chance that the defense had to remove the death penalty from this case, therefore seating a proper jury. It didn't happen. And when I dive into the details of it, there's some things that presented itself to me that stuck out like a sore thumb, answered some questions I've had for a long time, and I hope to answer those questions that you may not have even had. I hope to show you those questions and then answer them for you in this video, because there's some very interesting things that I've learned throughout this motion to preclude the death penalty due to disclosure violations process. And there's a few things that are glaringly evident that I didn't quite I started to put it together, but I didn't quite put two and two together. Well, now I have, and I'm going to show you that in this ruling. But the thing that is interesting when you really pay close attention to this, and you have for a long time, there's certain events for different things that seem to correlate in different times in this case that, you really got to pay close attention to even realize the things are correlating. And there's so many strange things in this case, I think you would agree, that just are beyond the realm of even imagination in some cases. For example, I have been, for the better part of a year now, bringing video after video about the OCD ETF and how they are the organized group responsible for tackling the major trafficking groups in this country. I've gone as far as to bring you videos discussing all of the various trafficking groups that they try to, take down, the organizations that are involved, that are part of the OCD ETF. I've even gone as far as to try to educate people on who is in charge of each group of the OCD ETF in their respective areas. And I've brought you things like, Nick Brown being the U.S. Attorney in Washington, Waldriff over in the Eastern District of Washington. And I've brought you many videos on Idaho and the person that's in charge in Idaho, which at the time was U.S. Attorney Josh Hurwitz. And then after all of those videos that I brought to you showing how Josh Hurwitz has had a life mission of trying to, even before he was U.S. Attorney, just as the state district attorney, trying to take down the Aryan Night groups. And then out of nowhere, what happens? All of a sudden, we get a special attorney assigned to the Brian Kohberger case, And it's none other than Josh Hurwitz. So, I mean, I couldn't write this stuff. I mean, nobody's imagination is that good, I don't believe. Stephen King couldn't write these things that is happening right in front of our eyes. So we got to stop and ask ourselves, is all this stuff just really some kind of magic coincidence, or is it all related? Well, there's a few things that I think are interesting when you start to relate facts in this case. And we're going to get into the motion to preclude the death penalty and its ruling, and what I think was a major factor in the judge ruling against it at this point. And I'll show you why I say that. But when looking at Josh Hurwitz, for example, and what he has been missioned with for the past decade, and then him being assigned to this case at a certain point that was very strange. And now I'm looking and I'm seeing what he's doing. They just filed some new motions. The prosecution wants to have their own psychological evaluation of Brian Kohberger as it relates to his autism. And that's being spearheaded by Josh Hurwitz. So that seems to be the role that he's taken on in respect to that. But it was something that the judge mentioned in the motion in limine hearing when we got to this particular subject that I pointed out, and it has stuck with me. And strangely enough, it's been referenced to again in his order. And then it let us know a little bit more about that particular subject in the order. And I went back and looked, and it's very, very strange to me. So first, let me show you what I'm talking about in the motion in limine hearing as it relates to this subject. Then we'll get to the judge's ruling. Then I'll show you some very interesting things that none of us knew until this video. So sit back, relax. Again, keep your socks on, folks.
Dad, can we have the death penalty?
Your Honor, that
You've gone a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already. And then things have happened since that point in time in this case that have set us back.
The skeptic would look at this and say, well, this is what Judge Boyce did when there was a last-minute discovery issue. This isn't a last-minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
I'd ask you to look at the things that have happened since our, I would say our status conference, the first time we met when I was hopeful that we could get through a number of the things that we still had left to do. I would say our status conference, the first time we met when I was hopeful.
Okay, so there's a couple things right there that I want you to just try to kind of log in your memory as we go through the order from the judge. One is the fact that he clearly brought up the Skyler Meade case that Ann Taylor had taken over as lead counsel on, almost as a point of contention. I mean, you can see that he isn't happy with her having that case, number one. And I mean, you could contemplate why he would be unhappy about that. I mean, obviously, Skyler Meade broke out of the prison at a hospital in Boise where Judge Hitler lives and created all kinds of havoc. So I'm sure he's not very fond of somebody like Skyler Meade, but it's obvious that is a bone of contention with him. And then the other thing you heard Ann Taylor mention was, well, the first time that, you know, we met in, well, let's call it the status conference, and we discussed these things. Keep that in mind as well, because there is some things that are going to come up in this order from the judge that I believe relate to those significantly. And there's a few other things that they bring up, which is why the judge says he's going to rule against this order. And we're going to discuss those in a minute. But first, let's go ahead and go through the highlights of this order by the judge to deny the motion to preclude the death penalty. And then I'll show you the interesting things that just kind of make me raise my eyebrows. So let's take a look. All right, so here's the new doc. And it's, again, the order on defendant's motion to strike death penalty and adopt other necessary procedures. And it's actually it was supposed to be the motion to preclude the death penalty due to disclosure violations, but this is how the judge has read it. Defendant contends that the discovery produced by the state in this case has been voluminous and unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for trial. Asserting his due process rights have been violated, defendant seeks sanctions in the form of striking the death penalty and imposing certain organizational requirements upon the state to aid defendant's review of discovery. The state responds that it has complied with all discovery obligations, including Brady, and there is no basis for sanctions or other measures. Oral argument on the motion was held on April 9, 2025, after which the court took the matter under advisement. Because defendant has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. The court further declines to require the state to provide further organizational assistance to defendant. That's kind of a move there. Let's see here. And when we get into the analysis, he focuses in on what the defense's original motion really focused in on. If you go back to a video that I did about it, I showed you all the things that the defense was bringing up as it relates to alternate perpetrators, co-defendants, and Brady violations. And that was what the judge, I think, was expecting to hear in the oral argument. And when the defense backed off on that, it gave him the ability to deny the motion, which I find very interesting at this point. But you can see down here, despite presenting this motion in briefing as a Brady violation, at the hearing on the motion, defendant confusingly requested that the court view the motion not as a Brady violation, but as a due process violation. See, that's interesting because they were suggesting Brady violations in the original motion, which leads me to believe now that they have pulled back on that and they're waiting for something else to file another motion, possibly a motion for sanctions to remove the death penalty like I originally suggested, due to none other than a Brady violation or, disposing of evidence that would be exculpatory to the defense, such as video, which would be Brady violations. But then again, when you look at this, the way the judge writes it, it says the defendant confusingly requested that the court view the motion not as a Brady violation, but as a due process violation. And then in his own words down here, it says, as the United States Supreme Court has explained, the Brady rule is based on the requirement of due process. So if the Brady rule is based on the requirement of due process, then why wouldn't they make this point as a due process violation? But anyway, let's keep going. Further, the state's experts who reviewed the various devices, including cell phones and other digital data, have disclosed opinions that they found no connection between the defendant and the victims from the devices and data, as if that would be the only relevant exculpatory information in all of that information. We know there's no connection to from Kohberger to the victims because Kohberger didn't do it. But then it goes down here and it says, excuse me, in addition, the state points out that on September 4th, 2024, at approximately the same time as its discovery deadline, it provided the defendant with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all the evidence received from the FBI, which comprises the majority, was provided to defendant with a searchable index. So September 4, 2024, right? At the discovery deadline, they give the defendant a 320-page index identifying the location of the discovery. September. I mean, this was like 6 months ago. This thing's 2.5 years old, and they just gave him 6 months ago the index to find the discovery. And you don't find some issue with that, Judge? Come on, man. Anyway, I'm not going to read all of the judge's justification here. But then again, right here it says his lead counsel insisted that she be, look at this. His lead counsel insisted that she be allowed to take on a second high-profile capital case despite the voluminous discovery in this case. Further, at oral argument, lead counsel indicated that her practice is to personally review all the discovery herself, rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need to be reviewed by lead counsel. And this little 10 right here, what does that mean? Oh, and look, under 10, we got the judge bringing it up again. State versus Skyler Meade, Nez Perce County. And it says October 8th, 2024, ex parte hearing, minutes sealed. So in that ex parte hearing back in October, on October 8th, apparently information disclosed between Ann Taylor and the judge about this Skyler Meade case must have had some real impact on this judge, because it's made him mad enough to where he's pointing out she insisted that she needed to be on that case. She reviews all the information in cases herself, and he's using this as a reason to deny this motion. What the heck did they talk about during that ex parte hearing on October 8th? Well, we know a lot of it must have been about the Skyler Meade case. So when we go down here to the bottom, based on the foregoing, defendant's motion to strike the death penalty and adopt other necessary procedures due to state's disclosure violations is denied. But let's talk just a minute about this, because this is some revelating information right here when it talks about this October 8th ex parte hearing as it relates to Skyler Meade.
We'll give that a shot. All right. If I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month, with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel?
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize that...
How much of the, would you say, 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. Okay. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows, because it doesn't sound like she's looked at it yet.
Not all of it, Judge.
Okay. All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing.
Now, this hearing that he was referring to that he was going to have with Ann Taylor after the October 8th hearing was known as an ex parte hearing. And an ex parte hearing is a court proceeding where only one party is present and is heard, while the other party is not present or given an opportunity to be heard. These hearings are usually used in emergency situations where immediate relief is needed, such as when there's a danger to a child or a need for a temporary restraining order. And we always thought that the ex parte hearing was because of the new law in Idaho about funding the public defenders, and we thought that the discussion going on in that hearing was whether or not Ann Taylor would be able to stay on the case or not due to the new funding issues. But now when we see the judge's reaction about her being involved in the Skyler Meade case as well, it starts to make me kind of question what all was discussed in that ex parte hearing, because, it seems like the judge was a lot more respectful to the defense in that first hearing you just saw right there compared to all of the hearings after that. So I went back to that point in time, and then I see these things that didn't make much sense at the time, but now I'm wondering what they pertain to. Motion for permission to file under seal documents related to the closed hearing regarding representation status on October 8th, 2024, to the closed hearing. And it says, come now, Brian Koberger, through his attorney of record, hereby request permission to file documents under seal for the court's consideration of representation status pending hearing on 10/8/24. The documents sought to be filed under seal are communications between the state public defender and counsel for Mr. Koberger related to contracting issues. These documents should be sealed to protect private matters and protect a fair trial. Private matters and protect a fair trial. Interesting. And then there was a notice of a filing related to the closed hearing, and it even says underlined under seal. And it's a different one. Come Brian Koberger through his attorney of record and pursuant to Idaho Court Administrative Rule 32I-1-2A-2E, and hereby files the accompanying documents related to the closed hearing being held on 10/8/24 under seal to protect the confidentiality of said documents. Now that looks like it could be something different. They don't mention anything about the, state public defender or anything like that, just about these documents and the confidentiality of these documents. And then there was the order for permission to file under seal the documents related to the closed hearing. The court having before it the motion for permission to file under seal documents related to the closed hearing regarding representation status and good cause is hereby ordered that the defendant shall be allowed to file the documents under seal related to the closed hearing. And then it says it is further ordered that the documents filed under seal, because of the confidential nature of information contained within the documents and that disclosure of the documents could impact a fair trial. It tells me that this is something a little bit more than representation status. And then them bringing up the Skyler Meade case over and over, I think lends it a little bit more credibility that this was something more than that. And what was interesting is Ann Taylor had taken over the Skyler Meade case long before this so-called ex parte hearing ever took place. In fact, I remember when she took over that case because I had been discussing the possible involvement of the Aryan Knights long before she took over that case. And it wasn't until she took over that case, because I never thought the Meade and Uppenauer prison break had anything to do with the case because it happened so long after it. But it wasn't until she took over that case and I started noticing little things that I looked closer into that Meade and Uppenauer prison break. Then that's when I discovered that once they broke out of prison, they made a 5-hour trek to Michael Burrows' front door. And Michael Burrows had just been arrested on that trafficking charge with Tanya Rhodes like 6 days prior to that. Obviously, something about that arrest provoked the prison break, and then they went 5 hours straight to his front door. Couldn't find him, and then they drove straight over to Orofino and unalived Kelly Farley's uncle. That's when I knew that, you know, there was definitely a connection between that prison break and our case. And Ann Taylor taking over that case, and then I noticed the subpoena that was issued in the Koberger case that has never hit the court docs. And it was almost the exact same date a subpoena was issued in the Meade case about housing Skyler Meade's brother Cody in Idaho as a material witness, that I went, it obviously has a correlation. And I believe at this point it has such a correlation that it's got the judge actually mad. Because after that ex parte hearing, you can see through every hearing from that point forward, he was a lot less respectful to the defense than he was in that initial hearing. Makes you wonder. There was also something else, though, that the defense brought up in that hearing that I think is very interesting, and it's going to make me keep my eyes open now for a silver car that could have been in the King Road neighborhood rather than a white car. Check it out.
About video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify. There very likely are vehicles, light and color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. Vehicles, light and color, white or silver, on all kinds of different cameras.
Now, when I originally heard Ann Taylor say that in the hearing about different vehicles, either white or silver, it didn't register to me as important. And then yesterday, when I was putting together the video on the defense's vehicle identification specialist and his background, I didn't correlate the two. But when I was putting this video together and I listened to that again, and I heard her say vehicles either white or silver, well, then it immediately made my mind register to the video that I put together yesterday on the defense's vehicle identification specialist and something that was said in his background of qualifications. And now it kind of is starting to make sense to me. Check it out. So when we go to the article written by Stephen Becker about vehicle identification from photos or videos, confirming or refuting vehicle make and model in videos and images, when it gets to the part about the vehicle color may be altered by reflections, camera color enhancement, and ambient lighting conditions, yellow or blue lights, colors in video are digital and represented by several factors that represent the color displayed. In physical color analysis, paint can be chemically analyzed to determine a match. Digitally, we can analyze the following characteristics: hue, saturation, luminescence, red, green, blue, and content proportions. So the fact that she made that statement, white or silver, and the fact that Mr. Becker is an expert in determining the color of a vehicle on a camera really makes me start correlating the two where I wouldn't have done that before. So I guess what I'm trying to say is it's really easy to get mad and let your anger take over whenever you get a ruling like we got from the judge. But then again, it's important not to let your anger take over and cloud your mind from being able to see the good and all the bad. By keeping an open mind and keeping a level head, you can then take the information that's provided to you in what should have made you angry, and it opens the doors to all kinds of things that you didn't notice before or you wouldn't have noticed. You see, now there is certain things that I will definitely be looking for going forward, and it just makes this entire case that much more interesting. And it tells me this. The reason I'm willing to bet that you could go through a lot of cases and you wouldn't have near as many questions, discrepancies, coincidences, and outright just things you couldn't even imagine being written in an imaginary tale. But it all seems to be there in this case. And I think the thing that makes this case so different from so many other cases out there is the fact that in this case, we actually have an innocent guy on trial. The other cases wouldn't have all these twists and turns and secrets and hide this, hide that, and what is going on over here, because they got the guilty party. Most of the time, I believe that law enforcement gets it right and they have the guilty party. But in a case when they don't get it right and they don't have a guilty party, well, that can be the only thing that makes sense when you see how hard the defense is fighting on every single thing out there. It certainly isn't just to remove the death penalty so Brian Kohberger, who's guilty of the crime, doesn't get put to death. They've actually got an innocent guy sitting there, and that's the only thing that makes all of this make sense. But you can bet that Skyler Meade case that Ann Taylor took quite a while ago is going to have a huge impact on this case. And now I think it's time for us to start looking into what vehicle, who was driving a vehicle that was similar to Kohberger's the night of the crime, but it was actually a silver vehicle, not a white one. That might give us some insight on who was actually driving that car. Please like and subscribe to this channel. Post your comments, thoughts, your criticisms. Till next time, Pavarotti's out.
Shot, only one of me to shield you all from the enemy. You're a superhero. You're a superhero.